Welcome back, everyone, to the deep dive. Ready for another deep dive today?
Always.
Excellent. Well, today we're going back in time to explore a really important and kind of fascinating period in American legal history, the Lochner Era.
Ooh, yeah. Lochner?
It might not be a household name for everyone, but it really did have a big impact on how we think about things like workers' rights and economic regulations, even to this day.
Absolutely. It's foundational.
And it all revolves around this, how the Supreme Court was interpreting the Due Process Clause, particularly when it came to economic liberties way back in the late 1800s and early 1900s.
Yeah, the turn of the century. Very interesting time.
So basically, we're going to be looking at how the court was deciding not just whether the government was, dotting its I's and crossing its T's in terms of like procedure, but also whether they had a good reason for doing what they were doing, especially when it came to interfering with people's freedom to make contracts.
That's right. It's about the why behind government actions. It's called substantive due process. And it gets pretty complicated, but also fascinating.
So it's not just are they following the rules, it's also are these rules like fair? Are they justified?
Exactly. And I think a good analogy to help understand the difference between procedural due process and substantive due process is to think about something like parental custody rights, right? The procedure is all about making sure the government is following the correct steps, like are they holding a fair hearing? Are they giving everyone a chance to speak? Things like that. But the substance is about looking deeper. It's about asking whether there's a solid reason for the government to even get involved in the first place. Is there evidence of abuse or neglect that justifies the government stepping in and maybe taking a kid away from their parents? So you can see how the substance of the matter can be just as important as the process.
Yeah, that's a really clear way to think about it. So how did this whole concept of like economic substantive due process come about? Was the court always so focused on this whole freedom of contract thing?
Well, not really. It's a pretty winding road, and it actually starts with the court initially being very hesitant to use the due process clause to protect economic rights.
So it wasn't always a given?
No, definitely not. In the early days, cases like Murray v. Hoboken Land and Improvement Co. and the Slaughterhouse cases show us a court that was pretty much saying, nope, not our problem.
So something must have changed for this to become such a huge deal later on. What was the shift?
You're totally right. And, even in those early cases, there were already some hints of disagreement. And you could see the potential for things to change. Like in the Slaughterhouse cases, for instance, you had justices like Field and Bradley who were strongly pushing back against the majority opinion. They were arguing for a much broader interpretation of due process, one that could protect those individual liberties, including economic freedoms like choosing your profession.
Interesting. So like a seed waiting to sprout.
Exactly. And then came some massive societal shifts. We're talking rapid industrialization. You have these big, powerful businesses popping up everywhere. And philosophies like laissez-faire economics and social Darwinism, all of that together really started influencing how people thought about the government's role in the economy.
Sounds like a recipe for some serious legal battles.
It definitely was.
Mm.
And the courts started sending out signals that they were paying attention and they were going to start scrutinizing those economic regulations more closely. For example, in Lone S and v. Topeka, they struck down a city ordinance using natural law principles, basically sending a message that the government had gone too far.
So they weren't directly applying the due process clause at that point, but they were definitely putting the government on notice.
Right. And then there were cases like Munn v. Illinois, the Railroad Commission cases, and Mugler v. Kansas. Now, even though the court ultimately upheld regulations in those specific instances, they started using language like real and substantial relation between the law and a legitimate government purpose. You can see them laying the groundwork for what's coming.
It's like the calm before the storm.
Totally. So you have, changing social norms, dissenting opinions on the court itself, these early cases kind of testing the waters, and then bam, the turning point, the case that really launches us into the Lochner Era, Allgeyer v. Louisiana in 1897.
Right.
This is where the court really draws that explicit line in the sand between the due process clause and freedom of contract.
Yeah.
A total game changer.
Okay, now we're talking. Tell me everything about Allgeyer.
All right, so picture this. Louisiana passes this law, basically saying, hey, if you're an out-of-state insurance company, you can't do business here unless you jump through all these hoops. And then this guy, he's a resident of Louisiana, right? He goes and buys insurance from a New York company that hadn't met all those requirements.
Oh, so like a loophole.
Yeah, you can see it that way. So, of course, it ends up in court. And the big question was, could Louisiana actually prevent its own citizens from entering into contracts with companies from other states?
What did the court say?
They sided with the Louisiana resident. They basically said, hold up. The 14th Amendment's due process clause doesn't just protect your physical freedom. It also protects your freedom to make contracts. And they declared that Louisiana's law was a big no-no because it was interfering with that fundamental right, especially since it was messing with interstate commerce.
Wow. So the government couldn't just regulate businesses however they please? That must have been a huge shift.
Oh, yeah, absolutely massive. Just imagine, you're a farmer back in the 1890s and suddenly the government tells you what price you can sell your crops for. That's the kind of thing the court was pushing back against. The Allgeyer case set a major precedent. It established freedom of contract as a protected liberty. And this is really where we step into the Lochner Era, where this principle really takes center stage.
Buckle up, folks, because things are about to get interesting. Okay, so Allgaier really set the stage for this big showdown between freedom of contract and government regulation. What happens next? How does this all play out in the Lochner Era?
Well, the Lochner Era is named after the landmark case, Lochner v. New York. And this case really took those principles from Allgeyer and kind of went for it. It definitely stirred things up.
What was so controversial about Lochner? Give me the rundown.
All right, so the case was about this New York law, and it tried to limit the number of hours that bakers could work each week. Like they wanted to protect these workers from, having to work these crazy long hours in really difficult conditions.
Yeah, I can imagine. 12 hours a day, 6 days a week. Not exactly a dream job.
Right. So the government, they were genuinely trying to help these bakers out, make their lives a bit easier.
Seems reasonable. So what happened?
Well, here's the thing. The Supreme Court, they didn't see it that way. They actually struck down the law. They said it was a violation of the baker's freedom of contract.
Hold on. So the bakers couldn't even agree to work longer hours if they wanted to. Isn't that kind of like, I don't know, counterproductive? Like you're trying to protect workers, but you're taking away their options?
Yeah, it does seem a bit odd on the surface, right? But that was the court's logic. They basically saw it as the government interfering with the right of these individuals to freely negotiate the terms of their employment. Like their view was that people should have the autonomy to make their own choices, even if those choices meant working long, maybe even unhealthy hours.
So it sounds like freedom of contract was the trump card, even if it meant some workers might end up exploited. Weren't they worried about businesses taking advantage of people, especially those who were, maybe desperate for work?
That's a good question, and it was definitely part of the debate back then. The court's majority opinion basically argued that these economic regulations, like that New York law we were talking about, they weren't actually about protecting workers. They were actually attempts to redistribute wealth and interfere with the free market.
So it was about keeping the government's hands off the economy, like a let the market decide kind of thing.
Exactly. Laissez-faire philosophy was super influential during this period. The idea was that less government intervention would lead to more competition, which would then lead to lower prices for everyone and, ultimately more prosperity overall. So they thought that by fiercely protecting that freedom of contract, they were actually protecting the free market itself.
But, wouldn't some argue that this hands-off approach could lead to worker exploitation? Especially for those who are in a tough spot and need to take any job they can get, even if the conditions are terrible.
Yeah, and you're right. There was pushback against that laissez-faire approach even back then. The Lochner Era wasn't exactly a period of complete agreement. Even within the court, there were voices of dissent.
So who were these dissenters? What were they saying?
One of the most famous dissenting voices was Justice Oliver Wendell Holmes, Jr. He argued that the court was basically imposing its own, economic theories onto the Constitution. He was like, hey, maybe the government should have a bit more flexibility to regulate things when it's in the best interest of the public, He thought that this super strict interpretation of freedom of contract was unrealistic and that it ignored the reality of the power dynamics between, employers and employees.
It's kind of wild to think that, over 100 years ago, these were the debates they were having, and it's so relevant today.
It really is. The Lochner Era started this whole conversation about what the role of the judiciary should be and how much power the government should have and what economic liberty really means. And those conversations haven't gone away. They're still happening today. We're still wrestling with these big questions about how to balance individual freedom with the need for regulations that protect people and try to ensure some fairness.
So this whole laissez-faire approach really had a lasting impact, huh? But I'm guessing this story doesn't just end there, right? What happened that eventually kind of led to the decline of the Lochner era.
Well, you probably won't be surprised to hear that the Great Depression played a pretty big role. That economic devastation of the 1930s, it really challenged the idea that, unregulated capitalism was always the answer. People were suffering. They were demanding that the government step up and do something to protect workers and regulate businesses and, provide some sort of safety net.
So the real-world consequences of this hands-off approach, they became impossible to ignore. Did the court, change their tune at all?
Yeah, over time they did. They started moving away from that strict, rigid adherence to freedom of contract.
Mm-hmm.
And they took a less, I guess you could say, a less aggressive approach to economic regulation. They realized that sometimes government intervention was actually necessary to protect people and to try and create a more level playing field. So that era of striking down laws just because they interfered with someone's freedom of contract, that was starting to fade.
So the pendulum swung the other way. Did the court completely abandon the whole idea of substantive due process, though? So they didn't just completely ditch the whole concept?
Nope, not entirely. They definitely became much less likely to use substantive due process as a shield for those economic rights, but they did keep developing the doctrine, just in other areas, like when they came to things like privacy and personal freedom. That's a whole other can of worms we could dive into sometime.
Yeah, let's put a pin in that. But okay, before we wrap up, I got to ask, why should our listeners care about any of this? This Lochner era stuff happened a long time ago. Does it really matter today?
Well, it might be history, but the questions that came out of it, they're still so relevant. Like, how much power should the government have to regulate the economy? What are the limits of individual freedom? How do we balance economic growth with protecting workers' rights? These are all things that every society grapples with, right?
Hmm.
And knowing the historical context, like understanding the wins and losses of different approaches, it can really help us navigate those tricky issues today.
It's like learn from the past so we don't make the same mistakes.
Yeah, exactly. The Lochner era, it's kind of like a cautionary tale about what can happen when the courts get too involved in actually shaping economic policy. But it also shows us how important it is to have a balanced approach to regulation, to find that sweet spot where individual freedom and the common good can coexist.
So it wasn't just about some bakers and their working hours. It was about these big ideas like freedom, fairness, and how the law really shapes our society.
Absolutely. And maybe even more importantly, it reminds us that those legal principles, even the ones that are enshrined in the Constitution, they're open to interpretation and reinterpretation as society evolves.
Mm-hmm.
Right? Something that seems like settled law in one era can be completely overturned or at least seriously modified in the next.
That's kind of mind-blowing. So the law isn't just some static thing. It's always changing along with us.
It's a living, breathing thing. Which brings us to you, dear listener. What do you think those limits of freedom of contract should be today? Are there times when the government should be able to step in and regulate economic activity, even if it means infringing on someone's right to freely enter into a contract? We'd love to hear your thoughts. The Lochner era might be over, but the debate that it sparked, that's still going strong. Thanks for joining us on this deep dive into the Lochner era. It was a fascinating one.
Always a pleasure. See you all next time.